group, and we are talking about maintaining CAH status today. A little bit of preliminaries here. As far as written materials, you should have received a copy of the PowerPoint. If you did not receive those, just shoot me or Charles an email and we'll make sure that we get a copy of the PowerPoints to you. In addition, we've made available to you a bunch of resources, primarily the stuff from CMS that talk about CAHs, the certification process, the requirements for CAH participation, all of that kind of stuff. These are kind of like the key issues for ensuring that you comply with and maintain your CAH status. As we go through the program today, it's going to be recorded. We will probably not take questions during the program, but if you have questions, you can go ahead and submit those to me using the chat feature on the program, which for some odd reason I can't see. But if you can't use that, then go ahead and submit it to me. Just shoot me an email and I'll respond to those questions offline. With that said, a little bit of background here. I'm assuming that all of you are with critical access hospitals or concerned about critical access hospital requirements. During the COVID public health emergency, a lot of those requirements were waived, but it looks like we're probably reaching the end of the public health emergency. Right now, that's currently scheduled to end on January 11th. I checked this morning and I didn't see anything that indicated that they were extending it beyond that. HHS has indicated that they would give us at least 60 days notice if they are not going to extend or if they're going to extend it. So that 60-day period would run tomorrow. So unless we get word by tomorrow, there's a good chance that that public health emergency is going to end January 11th, which means we need to go back to the old regulations, the prior stuff, and make sure that we're in compliance, not only with the critical access hospital requirements, but all those other 1135 waivers that were adopted under the public health emergency. When it comes to critical access hospitals, then you need to make sure that you satisfy the following. These is a general overview, and then we'll talk more specifically about each one. First, you've got to be designated by the state as a critical access hospital. You've got to be located in a rural area, which is generally defined as outside a metropolitan statistical area, or you've got to be in an area that is treated as rural. We'll talk more about that. You've got to be located in either more than a 35-mile, you've got to be at least 35 miles from the nearest hospital or CAH, or more than 15 miles if you happen to be in a mountainous terrain or only secondary roads, unless you've been designated by the state as a necessary provider. You've got to have no more than 25 inpatient beds and or swing beds, an annual average length of stay of 96 hours or less per patient for acute inpatient care. You've got to provide emergency care services on a 24/7, 365 basis, and you've got to otherwise comply with the conditions of participation that apply to critical access hospitals. All right, let's talk about some of those requirements. As a preliminary matter, to kind of set the stage, when the critical access hospital came out, it was really a boon to a lot of you who serve in rural areas because it provides substantial subsidies that are necessary in order to maintain your viable hospital in your particular region. But it was a lot more successful than the government thought, or at least there were a lot more critical access hospitals than the government anticipated. So the government's been looking at critical access hospitals for quite a few years. In 2013, the OIG conducted a report in which they found that 63% of the critical access hospitals would not meet the 35/15-mile distance requirement if they are required to re-enroll in Medicare, and OIG recommended that CMS periodically reassess the CAH's compliance with the location-related criteria. In 2016, the government issued a guidance and checklist for evaluating that CAH compliance with the location and distance requirements. And it kind of went on hiatus when COVID-19 came around. You got the 1135 waivers that just essentially waived pretty much all of the requirements for maintaining CAH status, but that's coming to an end. On June 6, 2022, the government issued proposed rules dealing with the rural emergency department, rural emergency hospital, but as part of that, they also issued some rules and had some commentary concerning critical access hospitals. Among other things, in the commentary, CMS noted the following. The distance requirements for CAHs must continually be met to maintain status as a CAH. CMS anticipates certain facilities may lose eligibility for CAH designation depending on the locations of hospitals and CAHs established within relevant distance of the CAH. CMS must continually verify the CAH distance requirements periodically to ensure that they are still met. CMS generally recertifies the distance requirements of CAHs every 3 years or upon a change of ownership as a component of initial certification or recertification. If there is a change in distance and location that does not meet the requirements, CMS notifies the providers of its option for continued enrollment in the Medicare program, which is basically you would either have to satisfy those requirements or you would have to recertify as a regular hospital, or I guess step out of the Medicare Medicaid program. The important thing here is that the government is switching back now and beginning again to look at CAH requirements. We're going to talk a little bit more about that later. So let's look at the first requirement. The first big one we're going to talk about is the location requirement. All critical access hospitals, including necessary provider CAHs, must either be located in a rural area or treated as rural in accordance with the regulations. Located in a rural area means that you are outside a metropolitan statistical area as determined by the OMB when they go around and do the Census Bureau and everything like that. Every 10 years they will look at that, and then the OMB takes a look at that and determines what is a metropolitan statistical area for purposes of HHS regulations. So in order to qualify as a CAH, you've got to be located outside a metropolitan statistical area and not classified as urban, or you've got to be treated as rural in accordance with 42 CFR 412.13. Now, there's been a lot of migration during the kind of COVID pandemic. A lot of the populations moved, and so you may need to make sure you monitor and check, are you in a metropolitan statistical area? If you are, you need to be looking for other opportunities in order to be able to classify yourself as a rural facility. Importantly, even if you're located outside an MSA, you've also got to confirm that the CAH is not classified as urban. I'm assuming most of you are not, so you don't need to worry about it. But nevertheless, you may want to look at these regulations up here and just make sure that you aren't, even if you're outside an MSA, that you're not in an area that's classified as urban. If you are within an MSA, you still may be treated as rural if you've been reclassified as rural in accordance with the regulations. That is, you have to be located in an area designated under state law or regulation as a rural area, or you have been designated as a rural hospital under state law or regulation, or you're located in a rural census tract of an MSA per the most recent version of certain commuting codes. Or you've got to qualify as a rural referral center or a sole community hospital if it were located in a rural area. The bottom line here is if you're located within an MSA and you have not otherwise been treated as rural, then you need to take appropriate steps to see if you can get treated as rural so that you can maintain your CAH status. Now, all CAHs must satisfy that rural area requirement, including necessary provider CAHs. If the CAH is no longer in a rural area because the MSAs have been reconfigured or the like, you've got 2 years from the date that CMS adopted that OMB MSA delineation to either establish that you have been treated as rural or convert to a Medicare certified hospital out of a CAH status. Importantly, that 2-year period runs from the time that the OMB designated that area as outside the MSA or within the MSA. It's not from when the government comes back in and tells you, hey, you are now within an MSA. The government expects you to be monitoring that. So for example, if you learn of this 1 year after that redesignation, then you've got 1 year to bring yourself in compliance. If you learn about it 3 years after the redesignation, then you're out of compliance and the time limit has passed. So it's the CMS places the responsibility on you all to monitor your compliance with that rural area requirement. In addition to be located in a rural area, the CAH must either be a necessary provider or satisfy that 35/15 mile proximity requirement. Let's talk first about necessary providers. If you're a necessary provider, and by the way, in order to get that necessary provider designation, you had to obtain that prior to January 1st, 2006. If you didn't, it's too late. You can't get it now. If you are a necessary provider, you do not need to satisfy that 35/15 mile proximity limit. That's an important benefit. The state agencies cannot certify necessary provider status after January 1st, 2006. So if you didn't get it back then, you can't get it now. If you don't have, or you don't know whether you're a necessary provider, you need to check with your state office of rural health or its counterpart to make sure that you can make that determination. If you are a necessary provider, you should obtain and maintain very carefully that necessary provider designation for your files, so that if the survey agencies show up, you can show that to them to confirm that you are in fact a necessary provider. Now, necessary providers run the risk that they may lose their CAH designation if they relocate or build a new or replacement facility. In either of those situations, they may no longer satisfy the critical access hospital requirements. When we're talking about a relocation, a renovation or expansion of an existing building, that's not a relocation or a new or replacement facility. You can go ahead and do that. That won't affect your CAH status. On the other hand, if you relocate to another address or you build a new or replacement facility, even if that new or replacement facility is on the same spot, even if it's got the same address, it's still considered to be a new facility, and therefore you've got to satisfy certain criteria if you want to maintain your critical access hospital necessary provider status. You can also lose your CAH status. A necessary provider CAH can lose its status if it opens up an off-campus provider-based department or facility. We'll talk more about that later. If it co-locates with another hospital or CAH, we'll talk about that. Or if you happen to terminate, you lose your Medicare provider agreement and you need to reapply or somehow get recertified, then it's too late to become a necessary provider. There are no new necessary providers. So if you lose that, then you lose your necessary provider status. Let's talk about relocation or replacement. So a lot of your facilities are getting old. You're looking at replacing them or maybe moving them to a larger location. In either of those situations, you've got to beware the impact that it will have on your CAH status. If a necessary provider replaces or relocates its facility, the CAH must satisfy the following to maintain its necessary provider status. You've got to serve at least 75% of the same service area that you served prior to the relocation. You've got to provide at least 75% of the same services that you provided in the prior location. And you've got to be staffed by 75% of the same staff, including medical staff, contracted staff, and employees that were on staff at the original location. If you go to the state office, the state operations manual, that citation there, it goes through this in quite a bit of detail on how you establish that, how you determine those 75% tests, and what you need to do in order to maintain your status as a necessary provider. If you are going to relocate or replace, the government says that you've got to submit a letter of attestation prior to the relocation, and that letter of attestation has to contain required elements as shown in this slide, and it's set forth in the state operations manual. You've got to notify the regional office of any changes during the implementation, and you've got to obtain a final determination, or the final determination will be made after the relocation or replacement is complete. This is potentially problematic. You may have a situation where you did everything, you thought you were right, but when the RO or SA comes in at the end of the day, they make that final determination after the relocation or replacement is complete. That's after you've incurred the cost to build this whole new facility, and suddenly now you've got to operate without the cost subsidies. So be careful with this. Make sure you work with the regional office and you jump through the hoops to maintain your necessary provider status. When it comes to necessary provider status too, this is another one where you could trip up. In order to maintain that necessary provider status in the case of relocation or replacement, you've not only got to satisfy the 75% test, but you've also got to make sure that you continue to provide the services based on the same criteria that the state originally used back before 2006 when it initially determined that you were a necessary provider. For example, if the state criteria only allowed necessary providers for HPSA, being located in a HPSA, then you've got to maintain that HPSA status. If you lose that HPSA status, then you can lose your necessary provider status if there's a relocation or replacement. So beware of that. You may want to go back and look at the original state plan that set forth the requirements for obtaining necessary provider status and ensure that you can continue to maintain that status if you're going to consider relocating or replacing your facility. All right, if you are a CAH and you are not a necessary provider, then you've got to worry about the 35/15 mile proximity requirement. That basically says that if you're not a necessary provider, the CAH must be located more than a 35-mile drive from any other hospital or critical access hospital, or more than a 15-mile drive from any hospital or CAH if either you're in a mountainous terrain or you're located in areas with only secondary roads that are available. Let's talk more about that. The 35-mile requirement basically requires you to document that there is no driving route from your CAH to any other CAH or hospital that is 35 miles or less in length. That probably means from another CAH or other hospital from their primary location, from their primary campus, not necessarily a provider-based outpatient department that the other facility built in your backyard. That 35 miles note is based on the driving route, not as the crow flies. Now, under the proposed rule that issued in June of this year, they proposed that 35-mile driving distance should be based on primary roads, not necessarily secondary roads, but they would modify it so that it only apply you've got to be more than 35 miles away based on primary roads. That would be a boon for you who are relying on that 35-mile test. Now, primary roads is defined currently under the regulations as a numbered federal highway, including interstates, expressways, or other numbered federal highways, or a numbered state highway with 2 or more lanes each way. So currently, for a primary road for a federal highway, it could be only 1 lane each way, but it has to be a federal highway. For a numbered state highway, it's got to have 2 or more lanes each way. Under the proposed rule, well, actually the CMS solicited, when they sent out the proposed rule, they solicited comments on whether that primary road should include only those federal highways with 2+ lanes in either direction, as is required for state highways. Again, if that comes out, if they make that change, that will make it easier for you who are relying on that 35-mile requirement. Well, even if you can't satisfy the 35-mile requirement, you're still okay as long as you can satisfy the 15-mile requirement. And there's different requirements depending on whether you are located in an area with only secondary roads or whether you're in mountainous terrain. With regard to the secondary roads, that means a drive of more than 15 miles without any primary roads to another hospital or CAH. Remember, primary roads are those that we just talked about, right? The federal numbered highway or a state highway with 2 or more lanes each way. In the proposed rule that they've promulgated, they have proposed modifying the primary roads to exclude. Another alternative for primary roads is a road shown in a map prepared in accordance with the U.S. Geological Surveys. They've proposed taking that out so that a primary road would only be those numbered federal highways or a numbered state highway if the state highway has 2 or more lanes. Again, CMS is listing comment on whether primary road should only include federal highways with 2 or more lanes in each way. That's for the secondary road requirement. The other alternative, if you don't satisfy that, is the 15 miles of mountainous terrain. That means that the roads on the travel route, that 15-mile travel route, must meet the following. It has to be over 15 miles of road that must be located in a mountain range identified on official maps or other public documents, and the road must be either steep and winding, with is defined as extensive sections with steep grades of greater than 5%, continuous, abrupt, and frequent changes, and so forth. Or it's got to be considered mountainous terrain by the state transportation or highway agency based on a significantly more complicated than usual construction techniques required to achieve compatibility, blah, 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 blah. The bottom line is, if you think that you have to rely on this mountainous terrain, you've got to go to the state transportation or agency department to actually verify that you are in that mountainous terrain, or that the 15 miles of roadway is in that mountainous terrain. Now, if you are relying on that 35/15 mile proximity requirement, you've got to be aware of new hospitals or CAHs moving into your market. CAHs that rely on the 35/15 mile limit, not necessarily provider CAHs, but just CAHs that rely on that 35/15 mile limit, must beware if a new CAH moves within that 35 or 15 mile limit. That would affect your status. Even though you were there first, CMS, at least under the current regulations, doesn't care. If another hospital or critical access hospital moves within that proximity, then that's going to jeopardize your status. In the proposed rule that came out in June, the CMS affirmed that its process will help ensure that CAHs operate under the CAH designation until or unless a hospital moves within 35 miles or 15 miles of the existing CAH. So a competitor could jeopardize your CAH status by opening up a CAH, or probably not a CAH, but another hospital within that 15 or 35 mile arrangement or proximity. That would, again, not apply to necessary provider CAHs, but it would apply to those who rely on the 35/15 mile proximity requirement. Again, that probably refers to a new hospital or CAH moving into that area, its main campus, not just opening up a provider-based or inpatient services that is not the campus. In addition to those requirements, both CAHs and necessary provider CAHs must be where establishing or relocating an off-campus provider-based location within that 35/15 mile requirement. Note that this requires to both CAHs and necessary providers. So it's not a situation where another hospital builds a facility, a hospital within your geographic area. Instead, this is a situation where you want to open up a provider-based clinic or another hospital-based facility within that area. If you do that and you build that facility within the 35/15 miles of another hospital or critical access hospital, then you may lose your own critical access hospital status. That mileage is calculated from the off-campus provider-based location, that facility you open up, to the main campus of the other CAH or critical access hospital. Now, this was more important back in the days when it actually benefited you to open up provider-based departments, given site neutrality. It probably doesn't help you much now if you were going to open up a new facility. That new facility is probably not going to be provider-based. You're not going to get increased reimbursements. So probably it doesn't make much difference. It could affect you, though, if you relocate an existing provider-based department within that 35/15 miles. So if you're going to change locations of your provider-based departments, be very careful because it could affect your CAH status. If you're going to open up one of those provider-based off-campus locations, the regulations state or the guidance states that you should submit an attestation to the regional office as specified in the state operations manual. If you don't, and the government comes in and determines that you have jeopardized your critical access hospital, they'll give you 90 days to either terminate the provider agreement, terminate that provider-based status of the off-campus department, or transition to a Medicare certified hospital. That limit on opening up another off-campus location, it generally applies to provider-based departments of the hospital. It does not apply to off-campus facilities that were in existence before January 1st, 2008, rural health clinics, ASCs, HHAs, skilled nursing facilities, and certain other entities that are listed on there that are not determined to be part of the hospital. If you want to know whether or not you're satisfying or check your compliance with the location requirements, you can look at the government's recertification checklist that you can access at that website right there, and you can go through that. If you have problems, then you may want to take a closer look and see what you need to do to make sure that you are complying. Under the proposed rule that issued in June, in the commentary that came along with it, the government reinforced that, hey, we're going to be looking at CAH location requirements. And part of the thing that I thought was particularly troubling is they announced a new proposed process for evaluating CAH status. Under this commentary, CMS said that they would use geocoding to identify all other hospitals or CAHs within the 50-mile radius. Those CAHs with no new hospitals within that 50-mile radius would be immediately recertified, but those CAHs with new hospitals within the 50-mile radius will receive additional review, focusing primarily on expanded healthcare capacity and access to care within the 35-mile radius of the critical access hospital being examined, and less on the actual roadway designations used in making the calculations. So it looks like they're even though the regulations say something else, it looks like the government may be trying to go with this new process for evaluating CAH status, and which is potentially troubling. So just be aware of that. In that guidance, the government emphasized that those CAHs that do not meet the regulatory distance and location requirements at the time of the review may face enforcement actions, including losing your CAH status. In addition to the location requirements, you've got to operate with no more than 25 inpatient beds. Those can be either inpatient or swing beds. When calculating the 25-bed limit, include any bed that's used for inpatient services at any time, including dedicated hospice beds. So if you're using it as an inpatient bed at any time, then you've got to count it. That 25-bed limit does not include beds that are used exclusively for outpatient services like observation, sleep studies, emergency services, etc. You can have up to 10 psych distinct part unit beds or up to 10 rehab distinct part unit beds. It doesn't count examination tables, operating tables, surgical recovery beds used exclusively for such. On the other hand, if they were used for inpatient services, they would count. Emergency department stretchers, beds in OB delivery room that are used exclusively for patients in labor or recovery after delivery, newborn bassinets, etc. So make sure that you keep a watch out for those beds. When it comes to observation beds, the government is suspicious of the use of observation beds, so be careful about that. Observation beds should never be used for inpatient care. If they are, then you've got to count those beds in your 25-bed limit. The government has indicated that observation beds should not be used for certain types of services, as reflected in that slide. In the interpretive guidelines, they said that it's up to you guys to provide clinical criteria to justify admission to observation versus inpatient. So you can't just try to circumvent the inpatient rules by putting them on something and they call it observation when it's really inpatient care. When it comes to your swing beds, remember that swing beds are certified separate from critical access hospitals. They're treated as long-term care beds, not necessarily hospital beds. You do not need those swing beds do not need to be physically separated from the acute care unit. The patients do not need to be moved when transitioned to swing beds. You do have to have a physician order that changes the patient from the acute care to the swing bed. Swing beds are not included when calculating the 96-hour average length of stay. For Medicare patients, a 3-day qualifying stay in any hospital or CAH is required prior to admission to a swing bed, and the admission must be for the treatment of the same condition. You've also got to satisfy that 96-hour requirement. That means that the CAH provides acute inpatient care for a period that does not exceed, on an annual average basis, 96 hours per patient. When your physicians or your practitioners admit patients, they've got to certify that the patient may reasonably be expected to be discharged or transferred to a hospital within 96 hours of admission to the CAH. That 96-hour average length of stay does not include swing beds, hospice patients, psych DPUs, or rehab DPUs if you should happen to have those. As a critical access hospital, you've got to provide 24/7 emergency care, 24/7, 365. That just means that the services are available. It doesn't necessarily mean that they have to be staffed at all times or the people have to be on site, but they've got to be available, and there's got to be a process so that they can respond generally within 30 minutes, respond on site. You can get up to 60 minutes if you're in a frontier area or under certain circumstances. You can use an RN to satisfy those requirements in limited circumstances. You got to have your MD or DO immediately available 24/7 by telephone or radio. Remember that these are for the CAH requirements. Your state may and probably does have additional requirements that you may need to satisfy the licensing. For CAHs, your med staff must have at least one MD or DO. You may also have APPs or CNSs. Professional staff must be available to furnish the patient care services at all times the CAH is in operation, and your RN, CNS, or LP on duty whenever there is an inpatient. Again, check your state law requirements. If you do not have an MD or DO on site 24/7, then you've got to notify the patients, including residents. You've got to notify them that the MD or DO is not on site 24/7. You've got to provide that notice to inpatients, whether planned or unplanned, and outpatients under observation or having surgery or other procedure under anesthesia. You've got to provide that notice at the beginning of the encounter. For a planned encounter, this is when you provide that package of information for a planned visit, etc. You've got to obtain the patient's signed acknowledgement. For ED patients, you've got to post that notice in your emergency department along with information concerning how the hospital will provide care when there is no MD on site. It's easy to kind of get a little bit lax on this, but you may want to go back and check your notices, check your processes to ensure that you're satisfying that requirement if you don't have that MD or DO on site 24/7. In addition to all of that, you got to comply with the conditions of participation that are applicable to CAHs that are contained in 45 CFR 45.601. I'm not going to go all through that. You guys know all of that stuff, but beware of this. Under that proposed rule from June, the government is proposing to add a whole bunch of new requirements concerning patient rights. These would essentially track the requirements that apply to regular hospitals now, but have not applied to critical access hospitals. Now you would be held to basically the same standard as regular hospitals when it comes to things like you've got to provide a notice to the patient of their patient rights. You've got to establish a grievance process. You've got to, there's requirements for informed consent and advance directives. You've got to provide care in a safe and private setting, ensure confidentiality of and access to patient records, and there's requirements concerning restraints and seclusion, and you've got to make sure that you comply with patient visitation rights. Again, these are proposed rules. Don't know whether they're going to get finalized, but I can't think of why they would not. So anticipate that coming down the pipe. The proposed rules do accommodate situations where if your CAH is part of a multi-facility system, they made it a little bit easier for you to satisfy the rules when it comes to things like staffing and staff responsibilities, infection prevention and control, quality assessment and performance improvement programs. You can do it kind of on a multi-facility system basis rather than simply with your own critical access hospital. All right, some other things that you need to be aware of. If you're a critical access hospital, beware of co-locating with another hospital or critical access hospital, or co-locating or sharing space with another healthcare entity, whether it's a physician office, an ancillary service provider, or whatever. If you co-locate or with another hospital or CAH, then obviously that could affect your critical access hospital status. It could also, if you co-locate with another hospital or CAH or with another healthcare provider, it could affect your ability to comply with the conditions of participation and the provider-based status rules. We'll talk about that a little bit further. When it comes to co-location of another hospital or CAH, generally the rules are, hey, necessary providers, you cannot co-locate after January 1st, 2008. If it was in place before then you can continue on. Other than that, you can't do it now. For regular CAHs, you may not co-locate because you wouldn't be able to satisfy the 35/15 mile rule. Other situations involving where you may allow others to use hospital facilities could jeopardize your provider-based status location at that particular facility. This came out, kind of shocked a lot of us in 2015. St. Peter's Hospital in Helena, Montana, they had, like a lot of us, they had a medical office building or facilities that were provider-based status. They wanted to allow or lease out some of that space to visiting specialists. They did so. The government came in, or actually St. Peter's submitted an application so that they could get certified, make sure that those facilities were provider-based departments of the hospital. And the government came in there and said no. Because they allowed others to use that space could not be considered provider-based because it was not operated under the same license, ownership, and control as the main provider. And the facility, in order to satisfy the requirements for provider-based department, it has to be held out to the public as a part of the hospital. And if you're allowing other people, outsiders, to use that space, then you can't satisfy those requirements. So in that particular situation, not only did the government fail to certify that that location was not provider-based, they also demanded that St. Peter's repay $1.5 million for services that were billed as provider-based that the government said was allegedly improper. Well, this sent kind of shockwaves through the healthcare lawyers like me who said, well, what do we do about all these leases for provider-based status? The government kind of changed its position over time. Through 2011 to 2017, the government seemed to be taking kind of a hard line, saying for those, if you're going to allow others to use your space, you got to have an exclusive lease for that space, and you got to satisfy certain other criteria. In 2018, 2019, the government kind of seemed to walk back a little bit from that and suggested that, okay, you can do leases, but you could also do timeshares as long as the hospital maintains control of its space as necessary to comply with the conditions of participation. In 2019, CMS issued draft guidance for hospitals discussing the co-location requirements, and they went through very, very detailed requirements concerning what the hospital had to do in order to satisfy the conditions of participation. I mean, it was very specific about the types of hallways you had to have, infection control measures, and all of these types of things. In 2021, the government revised that guidance to provide less prescriptive, more general guidance. So if you haven't looked at it yet, you ought to get that 2021 guidance to take a look at it to see what the government's perspective is currently on these co-location or allowing others to use hospital space. Now, big caution, however, this guidance was directed towards hospitals, not necessarily critical access hospitals. In fact, the guidance specifically defines healthcare providers to exclude critical access hospitals and physician offices. That leaves CAH in a little bit of a quandary about where we are when it comes to the co-location situation. The bottom line is probably this. Be careful if you're going to lease or share CAH space. If you're going to do that, you need to make sure that you comply with the CAH COPs that are relevant to the hospital space. That if others are going to be in that space, you better be darn careful that you're still able to comply with the critical access hospital CAHs conditions of participation, including things like infection control and the like. You need to, if you're going to, that space is provider-based, but you're going to allow others to rent out or use part of the space, you've got to maintain your continuing compliance with the provider-based rules, meaning that the hospital controls the space. If possible, you're going to want to physically separate the hospital space from the spaces used by the visiting specialists or those that are leased to those entities. Use signs or other means to distinguish the hospital space from that space that's used by those visiting specialists or outside entities. And you need to make sure that you continue to comply with applicable state requirements. The bottom line here is we're in a bit of a state of flux. It's a little bit gray when it comes to critical access hospitals. I think if you get that guidance for regular hospitals, that will help you. but just be careful of those situations. In addition, if you're going to allow others to use hospital space, you have to be aware of the fraud and abuse issues. If the hospital is billing the facility fee and the technical fee, and the other person, the visiting specialist, is just going to come in and bill their own professional component, that probably doesn't raise concerns based on guidance that came out in the most recent Stark changes. In that situation, it's like any other situation where you're allowing medical staff members to come in and perform surgery. The hospital bills its portion, the physician bills that portion. That doesn't result in improper remuneration to the physician. On the other hand, if the hospital doesn't bill that facility or technical fee, and the physician does bill it as if it were his facility, even though he's getting it for free, then that does constitute remuneration. It creates potential liability under Stark, the anti-kickback statute. If labs are involved, maybe under ECRA, potentially under state law requirements. If you do have a situation where you want to lease space to a physician or allow a physician to use your space, and the physician is going to charge for using that space more than just their professional component, you have to be aware of the potential Stark ramifications. There's probably no financial relationship if the physician is not the owner of the entity receiving the benefit. So for example, you have a physician who's employed by another hospital system, that hospital system sends that physician down to your particular location, probably not a Stark location because that physician's compensation from that hospital probably doesn't vary with the volume of value of that physician's referrals to you. And therefore, there's probably an indirect compensation relationship, so it's probably not going to be a Stark issue, maybe an anti-kickback issue. You would want to comply with Stark, check compliance with the lease safe harbor. Maybe it's a timeshare safe harbor if it's not exclusive. You might be able to fit within the payments by a physician safe harbor, the limited remuneration to a physician if it's a very isolated situation, and the total amount of remuneration to the physician is less than $5,000 a year. Personal services safe harbor, fair market value safe harbor. The bottom line is, if you're going to allow other physicians, referring physicians, to use your space or equipment, you better darn well make sure that you're complying with Stark. In addition to Stark, you've also got to comply with the anti-kickback statute. ECRA, if that provider is going to refer lab services. ECRA is particularly troublesome because ECRA is like the anti-kickback statute. In some ways, it's narrower because it only applies to referrals for labs. In some ways, it's much broader, though, because it also applies to not only referrals by that provider for items or services payable by government healthcare programs, but also labs. So if these providers are going to be making referrals to you, then you've got to really be concerned about ECRA as well as the anti-kickback statute. Also, of course, don't forget about your state laws. All right, that's a quick summary of kind of the rules out there, the things that are percolating concerning maintaining your critical access hospital and some of the issues that I've seen lately. The bottom line is, as we end this public health emergency, you got to make sure that you're towing the line on that. Just a word about the new rural emergency hospitals. As I mentioned, in June, the government set up this new entity, these rural emergency hospitals that are kind of like little tiny hospitals. They don't provide like the inpatient care and that type of stuff. I'm not going to go through any details about that. I'm assuming you're familiar with that. The bottom line is that in a recent study, they estimated that only 68 of the approximately 1,600 CAHs would actually convert to a rural emergency hospital. But if for some reason you think that that's something you're interested in, then you can follow up with that and see if you want to actually convert to that. All right, that is it for today. That is our summary. If you have any questions, feel free to send those in by using the chat feature or just shoot me an email offline and I'll respond to it as quickly as I'm able. Otherwise, I hope that that's helpful. This program will be recorded, and so you can listen to it later if need be. Otherwise, we always appreciate your participation. If there are topics or issues that you would like us to address in our monthly webinar series, by all means, let us know. And good luck out there.